turn your microphone on.
Thank you, Chairwoman Sanchez and members of the subcommittee. Thank you for the opportunity to discuss the many difficulties associated with holding foreign manufacturers accountable in cases involving defective and dangerous imported products. My name is Richard Schleter. I am a partner with the law firm of Childers, Buck & Schleter in Atlanta, Georgia. I've come here today to share with you my client's experience when she sought justice for the death of her 13-year-old daughter and only child. A defective foreign manufactured product was responsible for Lauren's death that occurred when she was seeking to meet her friends at the bus stop. The product was a Chinese-made electric scooter that was imported through the port of Long Beach, California, distributed and branded by a California corporation, and sold by a retailer in Gainesville, Georgia at a flea market. The defectively designed scooter, though marketed for children, was not a toy and was incapable of stopping a rider after a short time of operation. The product should have been required to meet federal motor vehicle safety standards and declared as such at customs. Proper inspection should have resulted in the detention of this illegal product at the port. Foreign corporations have learned to send non-conforming products that do not meet either certain safety standards or compliance or meet compliance regulations through specific ports. We knew a case against the Chinese manufacturer would be difficult. Under Georgia law, as in many other states in the United States, a distributor or end retailer does not have liability for design defects or defects in the manufacturing process. Our first hurdle was trying to locate the name of the Chinese manufacturer, since the scooter revealed no identifying information either by serial number or name. Once we uncovered the manufacturer's name, we realized that the company had no registered agent or office in the United States, even though the Chinese company claimed on its website that every year it exported $120 million in goods, including a wide array of toys and vehicles to U.S. retailers, including Walmart. After an unsuccessful attempt to get the Chinese company to acknowledge service, we performed service pursuant to the Hague Convention. This is a costly and complicated process for a variety of reasons. China is a communist nation ruled by a totalitarian government. An American litigant has no option but to turn service papers over to the Ministry of Justice, hope for the best, and wait. We translated the complaint, forwarded them to the Ministry of Justice, and waited 3 months for the central authority to serve a registered agent. Service was performed on the wrong individual, and this was later raised as a defense by the defendant Chinese company. After initial service of process, contact was made. The Chinese company sent a letter stating that they were reserving their right to, quote-unquote, ignore the charges against them. We obtained a default judgment against the Chinese company when the company did not retain a lawyer and file an answer. We knew the judgment would likely never be collected because China does not recognize the validity of U.S. judgments. We did not hear from the Chinese company again until we received notice that the company was appealing the judgment. The company appealed the judgment premised largely on lack of proper service and personal jurisdiction, claiming lack of contacts due to title of the goods that it sold and imported in the country passing at the port in Shanghai. In an effort to prove the Chinese company had minimum contacts to Georgia, we retained the services of a well-respected civil procedure professor from the University of Georgia School of Law, as well as 2 additional Georgia lawyers. We further hired law firms in Florida, Texas, California, and New York to assist in our attempts to locate assets, establish contacts, and assist in comity issues of domestication, and retained experts in the fields of service of process under the Hague, as well as experts in U.S. Customs. To remove any further argument of service, we attempted service yet again under the Hague, which took 8 months. This was required despite knowing in advance that the company representatives would be at a Las Vegas trade show and that the company designated a Shell Florida corporation for service of process requirements related to EPA and California Air Resource Board requirements. Meanwhile, we were also concerned that the Chinese company would try to avoid the judgment by fraudulently concealing and transferring any assets that it had out of the country. We later learned that such a transfer did occur in a multi-million-dollar wire transaction to Hong Kong within days of taking a deposition of a customer of the Chinese company. As a new Chinese company was now involved, adding it to the litigation would have required service under the Hague Convention with the additional costs and associated delay. I have relayed the aforementioned merely to summarize my recent experience on how foreign manufacturers who enthusiastically seek to enter the U.S. market do not have the same accountability as domestic manufacturers. In China, United States consumer protection laws can be ignored. Lately, we have seen this in the news with an array of products being imported, those most prominently highlighted from China being medicine, food, and toys. It is respectfully submitted this committee should look long and hard to the growing trend and problems associated with foreign manufactured goods and items reaching our ports with little oversight, protection, or inspection of the containers they arrive in. House Bill 5913 would allow a plaintiff to have additional avenues to expedite or ensure service of process for foreign manufacturers. This will at least give the consumer a chance to seek accountability when they have been harmed by a defective product. For these reasons, I strongly support House Bill 5913, the Protecting Americans from Unsafe Foreign Products Act. Thank you.
Thank you very much for your testimony. Mr. Schwartz.
Thank you, Madam Chair, and Ranking Member Cannon for inviting me here today.